think in film, everybody's always vying for power and control. I think that this is probably the most intense situation I've ever been in film. He was one of the few directors I've worked for that was very kind and respectful. In my opinion, I find it very hard to believe the allegations against him. And considering his mission statement about the film and him genuinely pitching that he was doing this film to help young women, I just find it hard to believe.
Hi, besties. It's Katie from Without a Crystal Ball. There's something that happens in litigation when you are being sued by a narcissist. There are times when narcissists want to and use litigation in order to silence people. Often, they will target individuals that speak negatively about them or have an unfavorable opinion of them. If it's a celebrity, they might target journalists, they might target content creators, they might target vloggers, they could target media outlets. It's a wide gamut. In Blake's case, she's targeting Justin's attorneys and now content creators. And why? Why is she doing this? Well, I have a hunch, and it's because ever since Justin Baldoni's lawsuit was dismissed, the focus by Wayfair has been targeted in one place and one place only. That's at the action between Vanzan Inc. versus Doe defendants, an action that was filed in New York State Court on September 27th, 2024, citing boilerplate arguments of breaches of contract and reputational damage based on third parties releasing information about them that was not favorable to them, and then subpoenaing only one person, JonesWorks, and then asking for the contents of a phone, Jen Abel's phone, who was an ex-employee of JonesWorks. The subpoena was issued on October 1st, 2024. The Vanzan Inc. company, according to filings as of yesterday, Mr. Ryan Reynolds is the one who claims to be the owner of Vanzan Inc. There are two companies with the same name, one in New York and one in California. The California company is forfeited. It's a revival of a defunct company, Vanzan Inc., that was revived by Blake Lively in 2021. Unfortunately, that business can't do business in the state of California because it's been forfeited by the FTB board, which is the Franchise Tax Board in California. They have outstanding judgments because the previous owners got involved in civil litigation for non-payment, labor disputes, and the FTC even got involved because they were doing illegal something with marketing lists. That company cannot do business, but Blake's name is on that company. That company is a foreign company with the primary company coming out of Delaware. In 2019, Ryan formed Vanzan Inc. in New York. Not as a foreign company, as a domestic company. That's a whole weird thing. So there's two separate Vanzans with the same address, different tax IDs. One is apparently Blake's company and one is Ryan's. And now Ryan is saying that his company is the one that subpoenaed JonesWorks for Jen Abel's phone. So one of the reasons why I believe they're panicking right now is because TMZ just leaks a story. No one else but Blake Lively's team would know this. And they're claiming that Blake has subpoenaed content creators, specifically 3 content creators that have large platforms that they believe are being fed information from the Wayfair parties. Content creators that are independent podcasters, journalists, vloggers, and those content creators are Candace Owen, Andy Signor of Popcorn Planet, and Perez Hilton. TMZ leaks the story about this, which is super hilarious because Candace Owens has denied she's been subpoenaed. I reached out to Perez Hilton, who I chat with here and there, and he directed me to a video that he made where he said that he hasn't been subpoenaed. He hasn't been served with any documents. And he questioned the legitimacy of the story because today is the deadline for substantial production of documents. And he noted in his YouTube video that I would say is pretty accurate that nobody in this case has been subpoenaed since like May. I think the Daily Mail journalists and the Page Six journalists, they got subpoenaed in April. And I think Blake subpoenaed Justin's attorneys at some point in May. And beyond that, the bulk of the subpoenas in this case went out in February and in March. And given that there's production deadlines here, it would be almost impossible for them to be able to comply with any discovery here because it's just too late. But she got headlines, right? And the headline that TMZ is thinking is that Candace Owens and Perez and Andy are all working with Baldoni and the Wayfair parties. And this to me is no different than when she started going after Shasti Flaw. And Shasti literally messaged me this afternoon and she said, "Oh my God, did you get subpoenaed?" And I said, "No." And she said, "Okay, I thought you would if anyone did." And I said, "No." And I said, "Have you?" And she's like, "No." And they've accused me of being a part of the smear campaign. So the primary content creator that they have been dragging for months, that they have asked every single Wayfair party to respond with with documents of their communications with Shasti, they never subpoenaed Shasti herself. They've accused her publicly of being part of a smear campaign. They have dragged Shasti's name through the mud. And yet, to this day, she has not been subpoenaed. Instead, what Blake is doing is she's going after, in the media at least, big names that have big headlines, that have backgrounds that can fuel feelings and sentiments from viewers and readers. I don't think this is an accident. I think her goals here are twofold. Now, technically, she can still subpoena them. So even though they haven't received one, doesn't mean they won't. They could very well end up being subpoenaed. The document deadline for discovery is August 14th. Today is the deadline for substantial completion, but that doesn't mean that they don't and can't still subpoena up until near August. Now, subpoenas, you get 2 weeks to comply. So, technically speaking, no one should be subpoenaed beyond the end of July because it would make it almost impossible for someone to be able to comply with the requirements and then to be able to go through the process to object and respond. And at this point, even today would be pretty late in the game. If she does subpoena, it's going to be obviously objected by all the parties involved. But why would she do this now? Right now, there's a lot of focus on the flaws in Blake's case, right? And right now, the bulk of the conversations that are happening with content creators are having to do with the Vanzan sham lawsuit. And what this sham lawsuit is exposing is that Blake and Ryan very well could have abused the court system through a sham action, which could make them liable for lawsuits for abuse of process, invasion of privacy. They could face criminal charges. They could be sanctioned. And most importantly, the evidence in the case could be completely thrown out. And her case is hanging on by a thread right now because in court last week, Blake told the judge that she got evidence from Jones Works through the Vanzan action. Jen Abel has told the court in a motion to compel that this sham action she believes was an abusive process and a way for them to gain access to discovery without filing a proper lawsuit and notifying the parties that their data and their information was about to be vulnerable to subpoena. Everybody in the United States has a right to object to subpoenas, and subpoenas are not an open invitation that you can just have anything that you want from someone. There are parameters, there are guidelines, and judges put into place what those are. And there are privileged logs, there is content that's not, you don't get to have just because you want it. And in this case, the judge already said that when Blake tried to subpoena their phones, the phone companies, for all of this data about them, he already shot it down and said it was an invasion of privacy. Well, we know that the Vanzan subpoena went well beyond what she asked for from the phone companies. So naturally, we have to hope that the judge would say that this was an overly broad, completely inappropriate subpoena. But it's not just that that's the problem. The sham action is just one issue. There's other issues that make this evidence completely vulnerable to getting tossed. And I think this is probably why Blake is, trying to drag in content creators. One, she wants to silence anyone that speaks negatively about her. And if she can tell the public that, hey, Perez and Candace and Andy, they cannot be trusted, anytime someone then watches them, they're going to be questioning, is this person working for Baldoni? Are they part of the smear campaign? And doing this now tells me she's lacking evidence to prove a smear campaign. She can't prove it happened on social media. She can't prove a digital campaign happened. She can't prove an untraceable campaign. So now she's got to go to the content creators who are commentating about a lawsuit that she filed in the public domain. So she's trying to, in my opinion, ruin their credibility so no one will take what they speak about as fact or with any validity. I also think that she's worried that her evidence might become inadmissible and her case could eventually get tossed because of what Jen brought to the court last week in the motion to compel. There's a big issue in the federal court in its civil rules of procedures, and that means that parties whose records or communications are subpoenaed must be given notice to allow them to object or move to quash. And lack of notice deprives the individual the due process and can render the subpoena materials inadmissible or subject to suppression. In this case, Jen Abel was not notified that her former employee was about to hand over all of her private data, even if she was a former employer, even if it was on a company phone. Stephanie did not have the right to hand over confidential information to Blake without notifying Jen. There's also an issue here with the transfer of discovery, which is, I think, part of the reason why they're looking for the communications between Vanzan, Jones, and Lively, because Blake has said over and over and over again that she got this through a legal court-ordered subpoena, but she didn't. Vanzan Inc. got it through a sham action subpoena. Blake Lively did not. Discovery in federal court can generally not be freely transferred or used in another other case without a court authorization, meaning Blake would have had to then subpoena Vanzan for the document. And the fact that they transferred the data from Vanzan to Blake personally without a legal process, it's a huge breach in the discovery process because it's how do you authenticate the evidence? The chain of custody of the evidence is, a question. Discovery violations, and now we're finding out metadata is missing. And so when you can't prove the chain of custody and you can't prove whether it's actually authenticated, right? Like this is the actual stuff I got from the phone, then that calls into question the legitimacy of it. There's also the whole thing about abusive process, because if she's using this primarily as a tool to issue subpoenas to obtain evidence, closing the case without it being challenged, courts frown on litigation as a pretext to collect evidence outside of normal discovery safeguards. And then there's also the issue with privacy violations by accessing the iCloud and iMessages, which protects electronic communications, and that's under the Stored Communications Act. And then there's other federal privacy protections like the Federal Wiretapping Act. And so I think what she's worried about is that they could be sanctioned for discovery misconduct. They could file motions to suppress or exclude evidence for lack of notice and privacy breaches. They could do a protective order to prevent further use or dissemination of the improperly obtained data. And if they can prove that this is what they did, they would have grounds for a lawsuit for abusive process, invasion of privacy, and any other related claims of action. And so right now, she doesn't want everyone to talk about the fact that she got this evidence through this sham action. And I talked to a lawyer today and I said, everyone in my comments keeps saying, well, what if, the judge looks the other way and turns a blind eye to this? What if the judge doesn't view this as a sham action? And they said that if a judge were to turn the other way, it would be a pretty significant ethical issue that could absolutely mean appeals. I asked them, I said, I just worry that he will dismiss and say the phone was company property because Stephanie will argue, oh, this was my company. I can do whatever I want. And she said he can. He could also dismiss because his fairy godmother told him so. Either way, he will have to try and make a legally sound justification which can survive appellate review. Otherwise, he will likely be overturned. I also asked, do you think the judge will rule that the phone belonged to Stephanie Jones and there was no expectation of privacy? And they said, I don't see how that is relevant. Let's unpack this. First, if Stephanie Jones' ownership of the phone means that all information was not private and should be admissible, why the need for a subpoena? In a federal court, a friendly third party can volunteer evidence that they legally own and it doesn't violate rights. So, no need for a subpoena. Second, it must be evidence that is probative towards a claim asserted in the case in which the subpoena is issued. Privacy or no privacy, what was the reasonably anticipated and stored on that phone, which could prove Vanzan had suffered damages owing to a breach of contract by an actual, not fictitious, Doe party. So, if it truly was Stephanie's to give, and if it was truly Stephanie's property, why would she have needed a subpoena? She needed a subpoena because she had confidentiality clauses. She had a clause in a contract with Wayfair that said she could not hand over any of their private and confidential information. Even remove Jen Abel as the person that has the communication. She's violating a contract with Wayfair and Baldoni by releasing information that she swore she would never release and would only release with a subpoena, court ordered, right? That's a clause in their contract. So it looks again like an end around. And same thing with Jen Abel. Just because it was a company phone doesn't give her a right to Jen's private data, especially in the Vanzan action, because what does her private data have to do with Ryan Reynolds' shell company? There's a lot of discussion with all of the lawyers that I talk to, and almost all of them believe that Wayfair needs to appeal the motion to dismiss order because it was done with prejudice. And they've all said the fact that it was done with prejudice denied them their access to a court for relief because everyone has an opportunity to go forward with claims. And if discovery is denied to them, and then after the fact, like right now, we're seeing what happened, they finally admitted it after the case was dismissed. They said, well, they need to file an appeal. And in the appeal, they could say that this dismissal was premature without discovery, that they uncovered critical misconduct and abusive process issues that were hidden at the time before he dismissed the case. They also could say that the lower court has erred by not allowing discovery to expose the misconduct. The judge kept saying in his motion to dismiss order that she was covered by litigation privilege and she was covered by, the fact that she made these claims in the CRD complaint. But a large majority of what he spoke about, Justin, and the claims against them happened before she ever filed a lawsuit. The breaches of contract, the interference, the defaming that was happening by Blake before she filed the lawsuit. He said, well, that's not even really defamation. He decided that. He didn't allow a jury to decide that. And he also didn't know about how the evidence was obtained for Blake, which is what they said all along, is that she violated our privacy by putting this out. And then he also said that there was no way that Ryan could ever be deemed culpable for defamation because he was a husband that believed his wife. But how does that then explain why Ryan's company is subpoenaing Jen's phone and he's doing it because of a breach of contract with his company, not with Blake's? Blake and Ryan are so paranoid about this case getting dismissed, and she'll be exposed as a liar and a fraud for bringing a frivolous claim, right? She did her victory tour before the discovery process was over because his case was dismissed. But, if she had such a solid case, she would have the evidence that she needs. And it wouldn't be because Wayfair's interfering. That's her that's interfering, right? But she's also so convinced of this smear campaign that she's now accusing Brian Friedman and his law firm of being a part of the smear campaign. So it's not just that she's subpoenaing Candace and Perez and Andy, although we don't really know if that's true. But now she's trying to subpoena the law firm that represents them and claim that they are part of it. In a letter to or in a motion to the judge in California, and there's a hearing on this in a couple days, Ellen Garofalo, the attorneys representing Brian Friedman's law firm, says that Lively contends that she is entitled to obtain documents from the law firm because it was a witness and agent for its clients in an alleged smear campaign. As evidence, Lively points to the LFTC partner Brian Friedman's prior representation of celebrity clients and public statements to the press made as Wayfair parties' lawyers. Shirley Lively does not contend that statements to the press entitle her to broad access to their files. Indeed, her own counsel has made numerous public statements regarding the litigation. Shirley Lively did not intend to invite a subpoena to her own counsel. Lively's subpoena should be seen for what it is, a fishing expedition meant to harass her opposing counsel based on a hypothetical theory of relevance. However, under Shelton, information requested must be crucial to the preparation of a case, not merely hypothetically relevant. Lively refers to Mr. Friedman's statements to the media after she filed her complaint. That's evidence of a smear campaign to her. Lively fails to show that the information she seeks meets any of the other factors under Shelton. First, the information could be obtained from the content creators themselves. So they're saying, why would you need to ask our law firm if we spoke to them? You can go to the content creators themselves. So that might be why Lively is now going to the content creators. Second, the requests encompass privileged information. Lively contends she is entitled to financial information because it might be relevant to her agency theory, even if LFTC uses those accounts for other purposes. She also contends it's entitled to all mobile phone billing records from every employee and agent because she believes they might be relevant to her theory of retaliation. She, however, fails to address the burden such as a request would entail for a third party, let alone privacy and privilege issues. Moreover, the requests are extremely broad with overbroad, ambiguous definitions. Ultimately, they're asking the court in California to deny her motion for these records from Brian's law firm. So that was filed last week, which I think the reason why she's now subpoenaing these content creators is because, well, I think she's knows that this is going to get quashed. There's no way they're going to give this to her. So if she wants to prove that these content creators were paid and fed information, then she needs to be able to get it from someone. They said that she contends that she's entitled to discovery from LFTC, which is the initials for the law firm, because it acted as an way agent of its clients in coordinating adverse statements about her to media outlets. First of all, litigation counsel are agents for their clients. Simply because a lawyer advocates for their client, even if it's reported by the press, does not entitle opposing parties to discovery of that lawyer's files. To hold otherwise would eviscerate the attorney-client privilege and work product doctrine simply by equating advocacy a retaliation claim. Ultimately, what she's after is silencing everyone because she views anyone speaking about this and calling her a liar and pointing out the truth as retaliation. Her theory of hypothetical relevance do not rise to the level of crucial required to obtain discovery from opposing counsel. She fails to address authority directly on point, instead relying on factually distinguishable cases. She's basically trying to say that she's entitled to this information from them because Wayfair speaking to anyone about anything is retaliation for her bringing forth claims of sexual harassment. But that's not how it works. Once you enter litigation, attorneys have a right to advocate for their clients, especially if they're public figures. They can make as many statements as they want. She then wants to somehow prove this nexus between the content creators and Wayfair and the law firm to prove that after the lawsuit was filed, these content creators are getting fed information from Wayfair. Even if Wayfair answered questions to content creators, even if Wayfair parties gave statements to content creators, her side has done it too. Even if they make a public statement like she has. I mean, she's made more public statements about this case than anyone on the Wayfair side. But if you Baldoni has said nothing. Jen Abel hasn't said a thing since the CRD complaint came out. Melissa Nathan doesn't have a social media presence. Steve Sarowitz has said nothing. Jamie Heath has said nothing. Jed Wallace has said nothing. There has been no public statements by anyone other than her. So she's going to try to claim that they're paying content creators, and that's proof of the retaliation because she can't prove anything else. And really, at the end of the day, she knows that her evidence related to the digital campaign is going to get thrown out. So now she needs to prove it somewhere else. If she knows that there was an abusive process here and it's likely going to become inadmissible, right? What's ultimately going to happen is she has to prove another form of retaliation. And that's going to be, well, they contacted content creators. Well, they paid content creators. No, they didn't. They haven't paid me. I haven't spoken to anyone that's been paid. A lot of people that are just talking about this are commenting on the public statements and the court records. So that's my take today, is that Blake and Ryan are panicking and they're trying to shift the blame because they know their evidence is about to get thrown out and they could be facing much more serious legal ramifications. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.